In order to properly formulate questions, we have to understand the different types of questions and what's called the spectrum of information and control. And that's what we're going to talk about today. Before we do that, let's remember what the goals of every witness examination are. First and foremost, the goal is to extract information from the witness that's helpful to your theory of the case, or information from the witness that undermines your opponent's theory of the case. It is only a last resort that we actually attack the witness. And of course, that's what everybody wants to do, is to attack the credibility of the witness. But the reality is that's what's called destructive cross, and we do that last. A little bit later in the semester, we'll talk about the reasons why that is always the last thing we do, and it is always tied to something we want the jury to disbelieve, or the finder of fact to disbelieve, that this witness has said. But now let's just talk about the basics of how to ask questions and understand that there is a spectrum of information control as we think about the different kinds of questions that you might ask a witness. On one end of the spectrum, we have one fact leading questions, where we have massive amounts of control, but we only get little bits of information. Now, on the other end of the spectrum are open-ended questions, and these are questions in which we get massive amounts of information, and the spotlight is very much on the witness, but we essentially surrender control of the examination and where and the facts that are going to come out from the witness, we surrender that to the witness. This, by the way, is where good witness prep comes in. And there's a couple of things in between in which we have sort of modicums of control, modicums of information, but we're going to talk about those in just a second. So first, let's talk about one fact leading questions. This is the foundation, the very essence of cross-examination. And cross-examination will always consist of almost exclusively, and at this point in your career, exclusively, one fact leading questions. And the first thing you have to understand about a one fact leading question is it's not a question. It is a statement of fact. So that objection, the lawyer is testifying. On cross-examination, absolutely the lawyer is testifying. You are stating a fact, and it is followed by an express or an implied invitation to agree. Now, that could be in the form of a tag. Could be, you are wearing a sweater, right? The sun is shining, correct? You would agree that you are watching a video, true? And so the tag follows at the end. But after you get into a rhythm, you don't necessarily need the tag, and simply you can invite that invitation to agree simply by using a down tick. In front of you is a computer. The computer has a screen. You are watching the screen. And you notice as I ask each of those questions, there's a slight down tick, which is an implied invitation to agree. Now, at the other end of the spectrum, where we get massive amounts of information, but we really surrender control to the witness. Those are open-ended questions. And open-ended questions are the heart of direct examination. And at least at this point of the semester, we're going to require that all of your questions on direct examination are open-ended questions, even though technically you may be able to get away with asking a leading or a closed-ended question. But we want you to practice this skill set. An open-ended question, by definition, will always begin with who, what, where, when, why, how, describe, explain, or tell me about. Where did you travel to today? How are you watching this video? And you'll notice there aren't a lot of boundaries. There are bookends around it in terms of I'm asking for a specific area of information. But ultimately, it really surrenders control to the witness, but we get a lot more information. Technically, when we ask a yes or no question, we're going to learn about how to enforce the yes. When we ask a yes or no, a closed-ended question, or a one-fact leading question, the answer is yes or no. With an open-ended question, well, there's a lot of information that can flow within the bookends. We're going to talk about how to control the witness when the witness goes outside of those bookends in a few minutes. Now, here's a technique, a pointer, something for you to consider. With open-ended questions are actually questions. You're actually asking the witness to explain or describe, or asking the witness to tell a story. And with open-ended questions, they end on an uptick. And the sad thing is that you can ask a closed-ended question, but if you end it on an uptick, it's still a question. You're wearing a sweater. The sun is shining. You're wearing a sweater. The sun is shining. And you can see the difference in terms of controlling the witness and the expectations you're setting, just in terms of the tone of voice that you use. Now, in the middle of the spectrum, we have two other types of questions. We have qualified leading questions. And qualified leading questions, well, they have qualifiers in them. They have things that allow the witness to speculate, that allow the witness to kind of quibble with you. And so you surrender control because the witness can pick on that thing and say, well, it's not exactly that. You are close friends with the defendant. Well, you know, we're friends. I don't know that I'd say we're close friends. You have spent a lot of time with the respondent. Well, okay, you see the thing? It's the a lot of. It's the qualifier. It's the thing that makes the kind of is subjective. And the witness can quibble with that as opposed to if you simply state facts. You know Ms. Smith, don't you? And Ms. Smith lives in the apartment immediately below you. You see her almost every day. Notice there's a slight qualifier there. And when you see her, you pass her on the stairway, but you've also had coffee with her. You have coffee with her on average about twice a week. And you notice that those are facts, and they're very different. They're leading. The answers are yes or no. We're extracting information, but I'm not allowing the witness to quibble with me by inserting those qualifiers. Now, further along in terms of the spectrum of control, where we really surrender control, is what we call argumentative leading questions. These are the questions that you know the witness is going to want to fight with you, because if they admit that question, either it makes them look bad, or it damages their testimony, or it makes their testimony not what they want it to be. It's something that usually contains a conclusion or an argument, and it's a leading question, but it's something the witness is going to want to fight about. As an example, you're a hypochondriac, aren't you? Now, most witnesses are going to tend to want to argue with that. On the other hand, if we're prepared when we ask that question, and usually we ask that question expecting the fight, wanting the fight, we have to be prepared to slide all the way back down to one fact leading questions. And so we might say, you're a hypochondriac, aren't you? No, I'm not. Well, let's talk about the first time that you went to the doctor, and specifically Dr. Smith. There you complained about, and then we start walking through factually, leading to the conclusion. And we probably aren't ever going to ask the hypochondriac question or that ultimate question again, but leading our finder of fact and our jury to the conclusion that the witness may want to argue that the facts take us to a specific place. And that type of question has a space in your skill set once you master one fact leading questions and open-ended questions. So, pop quiz. How many facts are in a one fact leading question? If your answer was anything other than one, well, obviously that's wrong. So what's wrong with this question? You're wearing a green sweater that's a pullover and it has buttons. Well, obviously there's a lot of facts there. We're going to practice how to thin slice, how to break things down into one fact, because the tighter your facts, the thinner those steps, those baby steps as you move forward, the more control that you have. And cross-examination is ultimately an exercise in the lawyer extracting facts that are helpful, but keeping the witness under very tight control. And so we're going to practice how to make sure we thin slice, because the tighter the facts, the greater the control. Now, how can I tell if I have more than one fact in my question? Well, obviously, if the question includes the word "and," that's a good clue. Yeah, you've got more than one fact there. And so that's at least two questions, and maybe more than that. We're going to do some exercises to break things down so that you can really work on making sure that you only have one fact. If your question has an adjective, something that provides, it's a descriptive term, chances are it has more than one fact. You are wearing a green sweater. Okay, well, I could argue with the fact that it's green. I could argue with the fact that it's a sweater. I could argue with the fact as to whether or not I'm wearing it. And so we might break that down to, you are wearing an article of clothing. You're wearing an article of clothing above your waist. It is a sweater. It has a color. That color is green. And so then we know exactly where it is that the witness wants to argue with us. And that is the essence of one-fact leading questions. Now, when we do direct examination, where we should be asking open-ended questions, questions that begin with who, what, where, when, why, how, well, a lot of times people are going to want to ask these to-be verb questions. Did you hear what she said? Were you at your office on January 1st? Did you get a phone call? When you got that phone call, did you go to 106 Arch Street? Okay? Those are all what we call to-be verb questions. And they are technically leading, because a leading question is one that suggests what the answer should be. A lot of times you'll see people using these, they'll argue that they're foundational questions, but they're not. They're attempts to essentially guide the witness down a very tight stream. And there's a problem with these to-be verb questions, whether it's, do you remember? Can you remember? Isn't it true that? Okay, all of those are leading questions. Can you tell us? Well, the answer to that is yes, I can tell you. So the answer to that is yes, even though a lot of times in our heads we drop off the can. We want to eliminate to-be verbs from our questioning technique. There's a better way to get to that place. We're going to talk about anchors, and we're going to talk about chapter setting a little bit later in the semester. But right now we want to get rid of the to-be verb questions on direct examination, and instead we want to substitute who, what, where, when, why, how, describe, explain, and, that's right, tell me about. And the reason why we want to do that is because when we use these to-be verb questions, two things happen. One, they're questions. We're surrendering some control to the witness. By the same token, we're actually focusing the information flow on the lawyer. And the reality is we want the information flow and the credibility to be with the witness. We want the witness to tell the story. So rather than asking those series of questions that I asked about going to 103 Arch Street, we might ask it like this. Detective, where were you on the night of January 31st? About 8:30 in the evening. I was in my office. And about 8:30, what, if anything, happened? Notice the what, if anything technology. We'll talk about why that's important later. What, if anything, happened? I got a phone call. When you got that phone call, what did you do? Well, I got in my car. When you got in your car, what did you do next? I drove to 103 Arch Street. When you got to 103 Arch Street, what did you see? Well, I saw the scene of the murder with the door wide open. Okay? So you'll see that it focuses the information flow from the witness. The problem with these to-be verb questions, they don't really fit anywhere on the spectrum. They're not leading in the sense that you're surrendering control, but by the same token, they are leading because they suggest an answer. And so we're going to practice on ways to eliminate the to-be verb questions from a vocabulary, and it's going to make your questions more precise and your witness examinations much more crisp. So, what's our takeaways? Well, as you probably have discerned, that while there are 5 if you count to-be verb questions, types of questions that you can use on direct and cross, really what there are for purposes of where we are at this point in the semester, we want you to practice the two primary ones. Open-ended questions on direct examination. Who, what, where, when, why, how, describe, and tell me about. And we want to practice those one-fact leading questions, which have, of course, one fact and which allow you to keep very tight control under this of the witness.